Probably mine, okay. Move that out of the way so I can see. There we go, okay. The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recess at any time. Pursuant to notice, I now call up H.R. 5904 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5904 to amend the Sherman Act to make oil producing.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. The No Oil Producing and Exporting Cartels Act, NOPEC, is a bipartisan bill whose enactment is long overdue. The fact that the Organization of Petroleum Exporting Countries, OPEC, is not being held accountable for its anti-competitive behavior makes a mockery of U.S. antitrust law. Consider that the Justice Department has been opposing a high-profile merger over consumers potentially paying 50 cents more a month. Meanwhile, academics call for a greater regulation to protect consumer welfare based on increasingly exotic antitrust theories. Yet nothing is done about OPEC's collusive activity, even though it appears illegal per se and is behind a rise in gas prices of over 50 cents a gallon since 2016. The lack of action is not a function of gaps in the underlying antitrust statutes. As the Supreme Court has explained, quote, under the Sherman Act, a combination formed for the purpose and with the effect of stabilizing the price of a commodity in interstate or foreign commerce is illegal per se, unquote. OPEC's organizational document under the headline Objectives states that the organization shall devise ways and means of ensuring the stabilization of prices in international oil markets, unquote. Federal law specifically provides that the Sherman Act applies to foreign conduct that has a direct, substantial, and reasonably foreseeable effect on U.S. domestic commerce. That is certainly true of oil prices. Unfortunately, courts have blocked efforts to hold OPEC accountable under these provisions. In 1979, a federal district court dismissed on the ground of sovereign immunity a lawsuit against OPEC brought by a labor union. But the same federal law that creates that immunity contains an exception for commercial activity. Nevertheless, the judge read that exception narrowly to avoid having to decide the case. On appeal, the Ninth Circuit did not reach the sovereign immunity question. Instead, it held that the suit was barred by the Act of State Doctrine, which is a judge-made doctrine designed to avoid judicial action in sensitive areas. H.R. 5904 removes the hurdles to hold OPEC accountable. It prohibits foreign state actors from cooperating to limit oil production. As explained, existing law already appears to do that, but the new language removes any doubt. The bill also makes clear that anti-competitive activities relating to oil production fall within the commercial activity exception to the Foreign Sovereign Immunities Act. Similarly, the bill provides that courts may not decline to hear an antitrust case relating to oil production under the Act of State Doctrine. Finally, NOPEC authorizes the Department of Justice, but not private parties, to bring suit against oil cartel members in federal court. This last provision is important because it ensures that courts would only be hearing cases that the executive branch affirmatively elected to bring after considering the foreign policy and national security implications. Despite strong support in Congress over a period of years, NOPEC has not yet become law. However, recently, President Trump signaled that he may be more receptive than prior presidents to measures that would counteract OPEC's adverse impacts. Further, while a private citizen, President Trump specifically endorsed a prior iteration of NOPEC. This creates a real opportunity to enact this long overdue legislation. Accordingly, on May 18, 2018, the Subcommittee on Regulatory Reform, Commercial, and Antitrust Law held a hearing on NOPEC legislation featuring experts in antitrust, foreign policy, and energy issues. Following the hearing, I introduced H.R. 5904 with strong bipartisan support. This markup is timely. OPEC's next meeting is scheduled for June 22, 2018. The time for action is now. This legislation is the right thing to do as a matter of antitrust law and to help consumers as we head toward the summer driving season. I'm proud to be the sponsor of this legislation. I want to thank the ranking member, Mr. Nadler, for his leadership on this, as well as Mr. Cicilline, Chairman Goodlatte, Mr. Marino, and Ms. Handel as well, and other members who have co-sponsored it. And with that, I yield back my time, and it's my pleasure to recognize the ranking member, Mr. Nadler of the Judiciary Committee, for his opening statement.
Thank you, Mr. Chairman. The Organization of Petroleum Exporting Countries, or OPEC, is an international cartel whose members deliberately collude to limit crude oil production as a means of fixing prices, unfairly driving up the price of crude oil to satisfy the greed of oil producers. Such behavior, if done by private companies, would be illegal per se under U.S. antitrust law. Because of a series of court decisions, however, U.S. antitrust enforcers are unable to protect American consumers and businesses from the direct harm caused by OPEC's blatantly anti-competitive conduct. H.R. 5904, the No Oil Producing and Exporting Cartels Act, or NOPEC, addresses these decisions by amending procedural law in a variety of ways and by expressly authorizing the Department of Justice to pursue antitrust litigation against OPEC members should it choose to do so. I'm pleased to join my colleague, Congressman Schaub, as an original co-sponsor of this legislation, along with Chairman Goodlatte, Mr. Marino, and Mr. Cicilline. The NOPEC Act would amend the Sherman Antitrust Act to add a new Section 7A that explicitly makes it illegal for any foreign state to act collectively with others to limit production, fix prices, or otherwise restrain trade with respect to oil, natural gas, or other petroleum products. This provision could be enforced only by the Justice Department. The bill also creates an exemption under the Foreign Sovereign Immunities Act to allow litigation against foreign countries to the extent that they are engaged in price fixing and other anti-competitive activities in violation of this new Section 7A. Finally, the bill clarifies that the act of state doctrine does not prevent courts from deciding antitrust cases brought against foreign governments under Section 7A. The NOPEC Act strikes an appropriate balance between allowing aggressive enforcement of U.S. antitrust law against OPEC to keep oil prices in check and respecting the separation of powers by deferring to the executive branch as to whether litigation is appropriate in any given case in light of foreign policy and the national security concerns. In 2007, I voted for legislation virtually identical to this measure, which passed the House with overwhelming bipartisan support. Although 11 years have passed since then, many of the reasons for supporting that legislation in 2007 remain valid today. OPEC controls more than 80% of global oil reserves, 40% of the world's oil production, and more than 60% of the petroleum that is traded internationally. When acting collectively, OPEC countries can greatly influence crude oil prices. Why should the average American care about this? Because the price of crude oil is the largest single determinant of retail gas prices. According to one estimate, crude oil prices accounted for 57% of the cost of retail gasoline as of February 2018. And the retail price of gasoline touches almost every aspect of Americans' daily lives, from the cost of commuting to the price of food and almost every consumer good, to the extent that such prices reflect transportation expenses. High gasoline prices, in addition to raising these costs and cutting into Americans' income, can also cause a vicious cycle of negative economic effects, such as causing consumers to cut back on purchases and limit their travel, which in turn hurts businesses and their employees. For a bill we last considered in 2007, one might be tempted to say that the concerns motivating the NOPEC Act are yesterday's news. In a somewhat literal sense, I agree. According to a CNBC report from last month, oil prices rose to $80 a barrel for the first time since November 2014. But recently, the U.S. Energy and Information estimated that U.S. regular gasoline retail prices over the period of April to September will rise to an average of $2.90 per gallon, which is 17 cents per gallon higher than it was in April, and up from an average of $2.41 per gallon last summer. That agency also reported that gasoline prices will reach a summer peak of $2.97 per gallon by June, and that this projected increase is primarily the result of higher forecast crude oil prices. I support the NOPEC Act because it would provide the federal government with one tool to address unfair retail gas prices. Nevertheless, I caution that it would be a mistake to think that enacting this legislation alone will fix the problem. Congress and the Trump administration should explore the other factors that also drive high gasoline prices, including an anti-competitive level of concentration among oil refiners, our excessive petroleum consumption as a society, and a heightened risk of war and instability in the Middle East. Passing the NOPEC Act, however, would be a helpful step. I thank the chairman and the sponsor of this legislation. I urge my colleagues to support this measure, and I yield back the balance of my time.
Thank you very much. Gentleman yields back. The gentleman from Pennsylvania, Mr. Marino, who's the chairman of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, is recognized for 5 minutes.
Thank you, Chairman. Last month, my subcommittee held a hearing on H.R. 5904, the NOPEC Act, of which I am an original co-sponsor. NOPEC is a long-standing bipartisan, bicameral bill that would expose the Organization of the Petroleum Exporting Countries, also known as OPEC, to U.S. antitrust law for its cartel behavior by removing the state immunity shield available to it under judicial precedent. In previous Congresses, NOPEC has passed both the House and the Senate by overwhelming majorities. The bill has yet to be enacted into law, however, and the need for enactment remains. The average U.S. household spends over $2,000 a year just on gasoline. That would be one of the things if fuel prices were set by the free market, but they are not. 60% of the total petroleum traded internationally is controlled by OPEC, and OPEC was founded in 1960. It has 14 member countries, including Iran and Libya. According to the U.S. Energy Information Administration, quote, production by OPEC countries is an important factor that affects oil prices. This organization seeks to actively manage oil production in its member countries by setting production targets, end quote. This collusion translates directly to consumers' wallets, since oil prices are by far the most important factor in determining gas prices at the pump. From 2008 to 2017, crude oil cost accounted for 61% of the average retail price of gasoline. In April 2018, OPEC and non-OPEC producers, led by Russia, agreed to continue an agreement they struck in 2016 limiting production. At the time, oil was at $43 a barrel. It's now at $63 a barrel. Given all of this, the American people would be right to wonder why OPEC has not been held accountable for its anti-competitive behavior in the oil markets. The fact is that over the years, consumers have tried to hold it accountable, but have failed because of essential judge-made barriers. The No Oil Producing and Exporting Cartels Act removes these barriers. Although existing antitrust law already appears to prohibit foreign state actors from cooperating to limit oil production, NOPEC makes that explicit in the Sherman Antitrust Act to remove any doubt. It also removes the immunity shields currently available under the judicial precedent. Specifically, NOPEC makes clear that anti-competitive activities relating to oil production fall within the commercial exception to the Foreign Sovereign Immunities Act. No wonder that NOPEC has enjoyed robust bipartisan support since it was first introduced in the 106th Congress and is identical to the version offered in both chambers of the 110th Congress. I want to thank my colleagues, Steve Chabot, for allowing this legislation to move forward and leading on the issue. Helping bring down gas prices for my constituents is a priority of mine, and this bill takes a significant step in lowering the price at the pump. With the summer driving soon approaching, I hope we can act swiftly in a bipartisan way to pass this important legislation that protects American consumers, and I yield back, and thank you.
Thank you very much. Gentleman yields back. The gentleman from Rhode Island, Mr. Cicilline, who is the ranking member of the subcommittee, is recognized 5 minutes.
Thank you, Mr. Chairman. Since 1960, the Organization of the Petroleum Exporting Countries, or OPEC, has colluded to manipulate the supply and price of crude oil with total impunity under our laws. Most recently, OPEC members announced a new agreement with 11 non-OPEC countries, including Russia, to manipulate oil prices by reducing production, which means that working people in our country end up paying more for gas for their car or heat for their homes. Cartel behavior like this is considered a hardcore criminal violation of the antitrust laws because it's an explicit agreement to collude in order to fix prices, reduce output, or allocate markets. The Supreme Court has referred to this anti-competitive conduct, which has no pro-competitive justification, as the supreme evil of antitrust. But unlike other cartels, foreign oil cartels are free to engage in anti-competitive conduct to fix the price of oil due to legal doctrines of sovereign immunity and act of state, which place firm limitations of the judicial process when it comes to resolving legal disputes with foreign governments. It's time for this practice to end. I'm proud to join my colleagues as the lead Democratic co-sponsor of the NOPEC Act, which will give Americans relief from the high cost of OPEC that OPEC has forced on them for decades. This bill, which passed the House and Senate with overwhelming support in prior Congresses, would allow the Justice Department to investigate and prosecute foreign oil cartels. It would do so by clarifying that commercial activity by other countries to limit the production or set the price of oil and other petroleum products is not exempt under the Foreign Sovereign Immunities Act or other judicial doctrines. While I strongly support the goals of the NOPEC Act, it's important to keep several caveats in mind as we move forward with this legislation. First, merely removing barriers to antitrust enforcement against foreign oil cartels by the Justice Department, as this bill would do, does not compel law enforcement in this area or constrain the department's enforcement strategies. Instead, the NOPEC Act authorizes the department to investigate and potentially bring these types of cases, which alone may be enough to discourage collusion by foreign oil cartels. Put another way, this bill gives the executive branch a tool to speak softly and carry a big stick. Second, this legislation is designed to serve as a complement, not a substitute, to diplomacy and thoughtful engagement with OPEC members and other countries that collude to withhold oil supply. As I'm sure my colleagues will agree, the NOPEC Act is not an invitation for any administration to politicize antitrust enforcement or pick geopolitical winners and losers. With this concern in mind, I look forward to including language in the committee report to make this point clear. And finally, the use of antitrust enforcement in this area, if used at all, should be part of a broader strategy toward energy independence. Antitrust enforcement alone is not a silver bullet to lowering oil prices. It must be a national priority to deploy and expand our capacity for clean energy production. I firmly believe that addressing oil consumption rather than oil production is critical to ensuring America's energy independence. Developing alternatives to oil consumption isn't just about combating climate change, lowering energy prices, or decreasing the market power of oil cartels. It's also about creating economic opportunity. In my home state, Rhode Island, is already hard at work to deploy innovative, clean, efficient energy solutions to deliver clean energy and address climate change. And in fact, just a couple of weeks ago, we announced the siting of the second wind farm in Rhode Island that, when fully operational, will provide electricity to half the households in our state. Furthermore, as one of our witnesses at our subcommittee hearing on this legislation testified, the Trump administration's flip-flop on fuel efficiency standards and other policies is a major step in the wrong direction that should be rejected by the courts. In closing, I want to thank Congressman Chabot, Chairman Goodlatte, Ranking Member Nadler, and Subcommittee Chairman Marino for their commitment to taking on foreign oil cartels through consideration of the NOPEC Act. This legislation is a testament to the committee's longstanding bipartisan tradition of investigating and addressing anti-competitive conduct that harms working families. I look forward to continuing this work with my colleagues to ensure that our economy is working for everyone, and yield back the balance of my time. And I would just like to ask the chairman if he would engage in a brief colloquy so that we can be sure that the record is clear that it is not the intention of the NOPEC Act to interfere or to be used in a way to pick political winners and losers, but rather to be used as a supplement to the diplomatic engagement of our country and to the work that the State Department does in working with OPEC countries, but to be a resource to really end anti-competitive and this collusive behavior, but not in a way to politicize or to pick winners and losers on the geopolitical stage.
If the gentleman would yield, I agree with the sentiment and the statement that the gentleman from Rhode Island just made. The purpose of this is to ensure fair competition in the oil market so that we can keep prices down for the American people, and it's good to see that we're doing this in a bipartisan manner. I would just add that I've offered this amendment a number of times over the years, oftentimes with our former colleague, Mr. Conyers, so it was bipartisan then, and this was under both Democratic and Republican presidents. So I thank the gentleman for raising that.
Chairman.
And as I said, I appreciate with the sentiment. Thank you. At this time, I would ask unanimous consent to enter the following letters of support for H.R. 5904 into the record. First, a letter of support from Securing America's Future Energy. Next, a letter of support from George Berman, a professor at the Columbia Law School and an expert in sovereign immunity and international trade. And thirdly, a letter of support from former senator from Wisconsin and chairman of the Senate Judiciary's Subcommittee on Antitrust, Competition Policy, and Consumer Rights, Herb Kohl. Without objection, so ordered. And I now have an amendment at the desk, and I would ask the clerk to read the amendment.
Amendment to H.R. 5904 offered by Mr. Shabbat. Page 2, strike line 19 and all that
I'd ask
follows.
unanimous consent that the amendment be considered as read, and I'll speak very briefly as the amendment is passed out. This amendment makes several primarily technical changes to the underlying bill. In particular, this amendment further clarifies that there is no private right of action under the bill. It also makes technical changes to eliminate duplicative language on sovereign immunity, rephrasing a sentence to conform to existing statutory styles, and rewording a section heading title to make it more informative. And finally, subsections are renumbered accordingly. As I mentioned at the Regulatory Reform, Commercial and Antitrust Law Subcommittee hearing last month, this is the fifth time that I've introduced this legislation since the fall of 2000. So we're going back 18 years here. So again, it's under both Republican and Democratic administrations. Each time when OPEC's price controls caused gas prices to skyrocket in my district and throughout the nation. Back in my home district in Cincinnati and Warren County, the price of a gallon of gasoline is nearing $3. This upward trend is devastating to middle-class Americans all over the country who rely on reasonable gas prices to reliably fill up their cars and trucks to be able to get to work, take their kids to school, or go to church on Sunday. Additionally, as chairman of the House Small Business Committee, which I actually have to chair the meeting at 11 o'clock, so I'm hoping we can wrap this up in 17 minutes. I also recognize the impact that rising gas prices will have on small businesses. As the price of gas increases, so does the price of shipping goods throughout the United States, putting pressure on an already razor-thin bottom line for many small business owners and ultimately having a negative impact on our overall economy. We successfully passed similar legislation in the House nearly a decade ago, but it stalled when the Senate considered it. And I want to again thank Mr. Nadler for his leadership on this issue over the years as well. Now we again have an opportunity to pass this important legislation into law. It's high time that we do more to fight the production controls that continue to keep the price of crude oil and gasoline arbitrarily high in the United States. Ultimately, NOPEC accomplishes that goal, holding foreign countries and entities accountable for violating U.S. antitrust law. I urge my colleagues to support this amendment and support final passage of this bill, and I yield back. The gentleman from New York, ranking member, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, in service of your desire to wrap this up in 16 minutes now, I will be brief. I support this amendment, which makes several technical clarifications to this bill. These include eliminating duplicative language regarding the bill's treatment of foreign sovereign immunity and language to clarify that the Justice Department has the sole authority to file cases under the Sherman Act against foreign oil cartels. I support this amendment. I urge my colleagues to do the same. I support the bill. I urge my colleagues to do the same. I yield back.
Thank you very much. The gentleman from Rhode Island.
I too, Mr. Chairman, will be very brief. I just want to underscore the point you just made that our small businesses, families that we represent are struggling with the high costs of fuel. It's something I hear about all the time from my constituents. One of the reasons that happens is because we have allowed OPEC countries, and now with this new agreement, it's OPEC countries plus 11 non-member OPEC countries that have the ability to frankly just decide that they're going to increase the price of gasoline by lowering the production. We don't let that happen in any other area. They're allowed to freely manipulate the market, and frankly, Americans have lived with this for far too long. This legislation will finally give us the ability to prevent that collusive behavior, drive down gas prices for our constituents. Your amendment is important in the clarifying language it provides. I urge passage of your amendment and the underlying bill, and thank the gentleman.
Thank you very much. Gentleman yields back. Are there any other members who wish to speak on this amendment? If not, the question is on the amendment. Those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. Are there any other amendments? Okay. All right. If not a reporting quorum being present, the question is on the motion to report the bill, H.R. 5904, as amended favorably to the House. Those in favor, say aye. Aye. Those opposed, no. The ayes have it. In the opinion of the chair, the ayes have it. The ayes have it, and the bill is ordered reported favorably. All right. Okay, members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and the staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 4423 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4423, to limit claims under federal law seeking judicial review of any environmental impact statement, environmental review, or authorization for the Lower Boys de Arc Creek Reservoir project in Fannin County, Texas, and for other purposes.
Okay, without objection, the bill is considered as read and open for amendment at any time. Excuse me. Okay. I'll begin by recognizing myself for purpose of an opening statement. Recent economic news tells us things have taken a strong turn for the better. Thanks to measures undertaken by Congress and President Trump, unemployment is down, and wages, economic growth, and small business confidence are up, up, and up. Part of the good news stems from the Trump administration's implementation of Congress' major down payment on permit streamlining during the last Congress. Title 41 of the Fixing America's Surface Transportation Act, or FAST. FAST 41 contained the biggest permit streamlining reforms in recent years. It has already begun to clear the log jams that have stood in the way of permitting decisions for many of the nation's largest proposed construction projects. But there remains much work to be done. The bill before us today, the North Texas Water Supply Security Act, highlights why that help is needed. Following over a decade of work by the North Texas Municipal Water District and environmental review in which the U.S. Army Corps of Engineers, the U.S. Environmental Protection Agency, and several other agencies participated, the Corps issued on February 2, 2018, with the EPA's consent, a Clean Water Act, Section 404 permit authorizing the Lower Boy D'Arcy Creek Reservoir project's construction. This $1.2 billion project will be owned, operated, and paid for by NTMWD, a state agency. The project is needed to assure that Texans served by the NTMWD can have online a new working water reservoir no later than 2025 and perhaps earlier to stave off a looming water crisis related to rapid population growth in the area. Construction of the project is expected to take 3 years, followed by another estimated 2 years at a minimum to fill the reservoir. Once operational, the reservoir is projected to help the NTMWD service water needs in its area until approximately 2060. The problem is that after North Texans already had to wait over a decade under old law for a project to be approved, the existing statute of limitations allowed litigants to challenge the permit in court as late as 6 years from the permit's issuance. To make matters worse, existing law allows such a lawsuit to be based on matters that weren't even presented to the Corps for its review during the Corps' painstaking decade-plus process. As a result, without further legislation, even the commencement of an action challenging the permit and any motion for a preliminary injunction against the project pending the litigation's resolution could be delayed until the eve of 2025 date by which the reservoir at the latest would actually need to be online, servicing North Texans and preventing a water crisis. The North Texas Water Supply Security Act solves that problem in a straightforward, common sense way. It allows litigation to be filed, but within a prompt statute of limitation. Further, it requires litigation challenging the permit to be brought in the U.S. District Court for the Eastern District of Texas. This means that all affected stakeholders can easily be present and heard in the litigation. The bill also requires litigation to be based on issues presented to the permitting authority during administrative review. Finally, it requires a judge entertaining motions for injunctive relief against the project not to presume that the adverse consequences of enjoining the project will be reparable. I urge my colleagues to support this legislation, and it's now my pleasure to recognize the ranking member of the Judiciary Committee, Mr. Nadler of New York, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I strongly oppose H.R. 4423, which takes aim at legal challenges to a single construction project, namely the Lower Bois d'Arc, I think it's pronounced it, Bois d'Arc Creek Reservoir Project, built by the North Texas Municipal Water District in Fannin County, Texas. Rather than allowing for the fair consideration in court of the merits of any environmental challenges to this project, this bill seeks to stack the process so that its supporters can ensure their desired outcome, facts or law notwithstanding. The bill includes several damaging provisions intended to restrict judicial review and to limit public participation for claims challenging the Bois d'Arc project. First, it would drastically reduce the statute of limitations governing petitions for judicial review. Under the Administrative Procedure Act, this period is currently 6 years. The bill, however, would reduce this period to just 60 days following the approval of the project by the U.S. Army Corps of Engineers, which, by the way, occurred on February 2nd of this year. Since 60 days have already elapsed, the substitute amendment that we will consider shortly would set the review period at 105 days from the date of the project's approval. But this is just window dressing, and it will not improve the bill at all. And notice that this sets up these very hasty requirements only for this bill. It does not, only for this project. It does not say that federal time periods and other requirements for litigation in projects generally should be changed, only for this bill so that we get, only for this project so we get the desired result. This legislation would also unduly restrict who may seek judicial review of this project by limiting it to only those entities that filed comments during the applicable public comment periods. Further, the bill establishes new standards for this project only that a court must consider in determining whether to grant injunctive relief. Among the most novel and telling of these new factors is the requirement that the court consider such reliefs, quote, potential for significant negative economic effects, unquote. While regulators routinely engage in such cost-benefit analysis, this requirement is far outside the expertise of the courts and is designed to lead to a negative conclusion. Cost-benefit analysis should be left to the regulators, not to the court. Finally, the bill imposes a variety of additional requirements related to the general obligation of parties seeking injunctive relief to secure a bond in case of a wrongful injunction. The cumulative effect of these additional requirements is to deter parties from seeking injunctive relief altogether by making it more expensive and possibly cost prohibitive, particularly for economically disadvantaged plaintiffs. For example, 9 landowners who filed a lawsuit challenging the project last month claim that this undertaking will cause them to, quote, suffer significant adverse consequences, unquote, because each of them will lose his or her property as a result of the project's construction. Given that the estimated cost of this project is well in excess of $1 billion, the potential bonding requirements under this bill would be debilitating for such landowners and would prevent them from seeking injunctive relief. The plaintiffs allege that the project, which is expected to cover more than 16,000 acres, presents serious environmental concerns and violates the Clean Water Act, among other laws. But rather than allowing for a full and fair review of these claims and the claims of other injured parties, the bill stacks the deck against them. Aside from the obvious substantive concerns with this bill, there is a larger question that must be asked. Why is this bill even in front of the Judiciary Committee at all? What expertise do we have over environmental laws? And what do we know about a specific project in North Texas, pro or con? There is already a perfectly good law in place, the National Environmental Protection Act, or NEPA, which sets forth guidelines and procedures for approval and consideration of such projects. NEPA, which was signed into law by President Richard Nixon in 1970, requires federal agencies to consider the environmental impact of certain projects and to ensure that the involvement of the public and other appropriate agencies. For the most part, NEPA has worked well, and the sources of any delay in the federal permitting approval process are not generally attributable to that act. These delays result from such disparate sources as insufficient project funding, concerns raised by state, local, or tribal communities, project complexity, and other factors unrelated to judicial review of the project's environmental impacts. Rather than having the committee with jurisdiction over NEPA consider any necessary amendments to that act, the supporters of this legislation instead seek to invoke our committee's jurisdiction under the guise of amending the Administrative Procedure Act, a law that applies generally to administrative law. And it does so with respect to one project only, which is a waste and an abuse of this committee's resources. In other words, instead of going to the committee which has jurisdiction over environmental law, which has expertise, which may actually look at the merits of this project, which may look at whether the requirements of NEPA should be changed or not, they come to this committee under the Administrative Procedure Act, a committee that has no expertise in administrative law, in administrative law, I hope we have expertise, has no expertise in environmental law, and knows nothing about the pros and cons of this project. Although the bill pertains solely to one construction project, I am also concerned that it may set a dangerous precedent for legislative copycat bills targeting other specific projects. In other words, when you have a project and it has questionable environmental or other impacts and you don't want it examined in the normal way that the environmental laws require, you come to this committee by seeking to amend the Administrative Procedure Act for the one bill. This is an end run, which is highly improper, gets around our environmental laws, around the committees with expertise and jurisdiction, and serves nobody's interests except the interests of sponsors of the project who feel that they can't or don't want to answer on the merits on the normal process. On the other hand, the limited applicability of the bill does provide some comfort. At least its damaging effects will be restricted to just one construction project, but that is no excuse. Accordingly, I oppose the bill. I urge my colleagues to do the same, and I yield back the balance of my time.
Thank the ranking member. I now recognize myself for the purpose of offering an amendment in the nature of a substitute. Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 4423 offered by Mr. Ratcliffe of Texas. Strike all that follows.
Without objection, the amendment will be considered as read. This amendment includes many of the provisions from the bill as it was originally introduced, as well as changes to account for the Army Corps' issuance of its record of decision and permit approval for the Lower Bodark Creek Reservoir earlier this year, and the filing in the Eastern District of Texas on May 11, 2018, of actual litigation challenging the Corps' permit approval. Specifically, this amendment extends the legislation's statute of limitations to 105 days from the date of the Corps' approval of the permit. The amendment also adds a grandfathering provision to allow any additional litigation filed after the legislation's specified statute of limitation, but before the bill's enactment, to have complied with that statute of limitations. And finally, the amendment redesignates the bill as the North Texas Water Supply Security Act of 2018 and ties the legislation's separate 60-day statute of limitation for actions challenging any supplemental environmental impact statement, or SEIS, required for the project to the date of the final agency action on the SEIS rather than on the publication of that action in the Federal Register. This legislation is the culmination of all of the hard work by the bill's sponsor, Congressman Sam Johnson. Without objection, I would ask unanimous consent to submit a statement for the record from Congressman Johnson in support of this bill. The Lower Bodark Creek Reservoir project is an extremely important potential water resource that will supply 1.7 million North Texans. Without this reservoir, it is projected that the project's local sponsor, the North Texas Municipal Water District, will not be able to meet the water needs of its customers by 2021 or 2022. The permitting process for the Lower Bodark has taken nearly 15 years, more than enough time for interested parties to raise issues with the relevant permitting agencies. Yet under current law, despite those 15 years those parties had to raise concerns, they would have an additional 6 years to interrupt the project with an injunction or a temporary restraining order. Without this bill, North Texas could complete 95% of the reservoir, and under current law, despite having 15 years prior to raise issues regarding the project, an outside group could stop construction and the ability of the North Texas Municipal Water District to serve 1.7 million Texans relying on that water supply. I therefore urge my colleagues to support this common sense measure, and I yield back the balance of my time and recognize the ranking member.
Thank you, Mr. Chairman. I oppose this amendment because it makes a bad bill worse. As I've already stated, the bill establishes a series of draconian requirements for claims challenging the Bois d'Arc project in North Texas. These severe limitations on judicial review are clearly designed to limit public participation and to shield potentially dangerous or environmentally harmful aspects of this project from public scrutiny and legal accountability. Because the U.S. Army Corps of Engineers approved this project back in February, however, the bill's 60-day statute of limitations for challenging this project in court, the bill's, not the existing law, has already elapsed. The substitute amendment, therefore, establishes a new statute of limitations for litigation relating to the environmental review of the project of 105 days from the date of the project's approval. As a coalition of public interest groups opposing the bill, including Earth Justice, American Access to Justice, and the Center for Biological Diversity, have noted, this new period established by the substitute amendment has itself already closed last month. Although this extension will enable the lone existing lawsuit that has been filed to continue, it forecloses any further litigation from being filed and is therefore nothing more than a fig leaf. In other words, we're foreclosing litigation in a process which we are shortening. Worse still, the substitute amendment would retroactively apply the bill's onerous security requirements to any existing legal challenges to this project. To date, we are aware of a single lawsuit which was filed by a group of local landowners and rural farmers who have raised significant environmental concerns, yet this amendment would further stack the legal process against them. As the Center for Progressive Reform notes, it is manifestly unfair to retroactively change the rules for those who have exercised their right to judicial review. And let me just state the following. This project may be a very necessary project or not. I have no idea. On this committee, we don't know anything about this project, about its pros and cons. All we know is that proponents say it's a very important project, which it may be, and that it's been under review for a long time, which may be the case. Opponents, I assume, say the project has deleterious effects outweighing its salutary effects and violates the National Environmental Protection Act in various ways. They should get their proper hearing in court. They should get their proper hearing. The effect of this bill is to say we are stacking the deck. We don't want them to get their hearing. And we're not saying that the process is unfair, that the process ought to be changed generally. No, we're saying it ought to be changed only for this project because we want to stack the deck for this project, because we are making the judgment that the local people in Texas who oppose this project are wrong. Well, maybe they are and maybe they aren't. I have no idea. But they ought to get their day in court. And now we're saying just in case, this one lawsuit which was filed on time under the time limits we're establishing now, just to make sure that they can't proceed, we're retroactively increasing the bonding requirements so that they may have to put up I don't know how many millions or billions of dollars in order to seek injunctive relief in court. We're saying, in effect, they can't get a review. Now, I must say that in my district, we had an experience like this many years ago, where we had a big project that the governor supported, the mayor supported, the New York Times supported, everybody supported, except some local people. And it was under review for a number of years, and it kept being under review because the administrative agencies kept lying in court. And every time they lied in court, you had to start we proved it, and they had to start the project over again, and they complained, oh my God, the project is taking so long, the approval is taking so long. Had they been honest, it wouldn't have taken so long. Eventually, we killed the project because they couldn't support it on the merits when they were honest. Now, I don't know if the same thing is going on here, but there ought to be the fair review. And the import of this bill and this amendment is to deny the local opponents a fair review. And again, if we think the review process is too lengthy, too onerous, too burdensome, then let the appropriate committees of the House review the general process, maybe amend NEPA or whatever and change the process and let the House consider that. But this project and no particular project, should be excluded. The local opponents of no project should be excluded from the normal opportunities of review just because someone has friends in Congress, and especially it shouldn't be done by a committee such as ours, coming in through left field from the Administrative Procedure Act instead of the Environmental Acts, which is really amending, which has no expertise, no knowledge, etc. This bill is the worst kind of special interest legislation for one special interest, a special interest I might approve of if I knew the facts. I don't know, but we shouldn't be doing this. We should let the process play out, let the local people have their proper opportunities to support it and oppose it. If the process is wrong, we should deal with that, but we shouldn't be saying the process goes on except for this project because they've got the political clout in this House to overwhelm the local opponents. It is wrong. I hope everyone will vote against the amendment and the bill. I yield back.
Ranking member's time has expired. Are there any amendments to the amendment? For what purpose does the gentlelady from Texas seek recognition?
I thank you, Mr. Chairman. I have an amendment at the desk,
I recognize the gentlelady on her.
001.
Yeah. I recognize the gentlelady on her amendment. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 40.
Without objection, the amendment is considered as read, and the gentlelady is recognized.
Frankly, Mr. Chairman, I'm quite aware of the challenges of water in the state of Texas. My amendment, I believe, is simply an act of fairness. It strikes the section of the bill that limits who may bring an action pertaining to an environmental impact statement, environmental review of, or authorization for the reservoir project to parties who submitted a comment during the public comment period on that environmental impact statement for the reservoir. My concern is that we're talking about the average citizen, the everyday working man or woman, who may not even understand the process of comment on a regulatory process. And so I think it is unreasonable and unfair to expect any given citizen who may be harmed by a government project to participate in the notice and comment period, given most Americans probably are not even aware of such period. It takes a big stretch to be able to find out where that notice and comment is. And so we all are supportive of water needs. All of our colleagues are. But in the process of the responsibilities of the Judiciary Committee, I think it is important to realize an actual fact. A regular citizen is just not going to be aware that a comment period went forward. I ask my colleagues to support the Jackson Lee amendment.
Chair recognizes himself in opposition to the amendment. H.R. 4423 includes a venue restriction to the Eastern District of Texas for a simple common sense reason. That is, make sure that those who are directly affected by the relevant reservoir project, including those in need of the water it is needed to provide, will have full and ready access to be heard in litigation over the project.
Let me explain it again, Mr. Chairman. The provisions in the bill indicate that only those who made a comment on the comment period would be allowed to further pursue any issue. And my point is that all of us understand the regular citizen who may not be even aware a comment period is in process. And I'm suggesting that we not bar that person who didn't make a comment originally from having the opportunity to express their views. It is unreasonable, unfair to expect any given citizen who may be harmed by a government project, wherever it is, to participate in the notice and comment period, given most Americans probably are not even aware of such a period exists. With that, I ask my colleagues to support the amendment.
All right, now I think I can talk about this amendment. As with its venue restriction, H.R. 4423, for a simple common sense reason includes a requirement that a litigant challenging the relevant permit have actually submitted comments during the administrative review of the permit application. That is to make sure that litigation is not brought based on arguments the agency never had a chance to consider. Such sandbagging litigation, if allowed to proceed, unnecessarily threatens to prolong even further the day on which it will be ultimately settled whether the project at issue can be completed. In the case of this project, that could mean an unnecessary water crisis will be thrust on North Texas by someone who sandbagged a reviewing agency and everyone else with a stake in the project. So for that reason, I cannot support the gentleman's amendment. First, the gentleman from New York seek recognition.
Mr. Chairman, I move to strike last word.
Gentleman's recognized.
Thank you, Mr. Chairman. I support Ms. Jackson-Lee's amendment, which strikes the bill's onerous requirement that parties seeking judicial review of this project must have filed comments in the project's underlying permitting process. As I've already stated, among the bill's damaging provisions to limit judicial review and public participation in environmental permitting decisions, H.R. 4423 also forecloses review for any party who does not file comments during the applicable public comment period. These severe limitations on judicial review are clearly designed to limit public participation and to shield potentially dangerous or environmentally harmful aspects of the project from public scrutiny and legal accountability. We are aware of one single lawsuit which was filed by a group of local landowners and rural farmers who have raised significant environmental concerns with this project. It is unclear whether they filed comments in the underlying permitting decision. But why should that matter? Why is the majority less interested in the concerns of local farm owners and communities than they are in stacking the deck against any review of this project, no matter how meritorious the claim may be or how dangerous the potential harms may be? I strongly support this amendment, and I urge my colleagues to do the same. Before closing, I ask unanimous consent that letters from the Center for Progressive Reform and the Coalition of Access to Justice groups, including Earth Justice and the American Association of Justice, in opposition to this bill, be made part of the record.
Would the gentleman yield?
No. But
Yes, that objection will be made.
Thank you. I'll yield.
Would the ranking member yield? Would you yield for a question or two on this?
Sure. Yes.
So the full import of this is just kind of weighing in on my mind here. What we're doing with the underlying bill is taking a basic administrative law structure and then nullifying it for one category of people who have a complaint. Is that right?
For one project, yes.
For one project, okay.
Well, not only that, using a change in the Administrative Procedure Act, in effect, to abrogate the National Environmental Policy Act for one project.
Okay, and so as I understand Ms. Jackson-Lee's amendment, she's saying, at least let's chop off the second part of this, which says that you don't have the right to sue unless you actually submitted a comment during the comment period. Now, let me get this right. Is that like saying you wouldn't have a right to challenge a law passed by Congress unless you had testified against the law first or you had objected to the law before it was enacted?
In one sense, and bear in mind that the comment period is past tense. We're not saying that if you want to protect your right to sue against this project, be sure to file a comment. The comment period's over.
Yeah. Is it right that we've had no hearing on this legislation? Has there been a hearing on this legislation? Or there was a hearing?
No, there was a, when was the hearing? There was a hearing last month.
There was a hearing, okay. Was there any consideration of the constitutionality of what the underlying bill is doing? In other words, have we looked at the due process and equal protection implications of saying we're going to revoke the entire administrative law protective structure for one category of cases and doing it retroactively?
My understanding is that the hearing was in the Administrative Law Subcommittee, and questions of constitutionality were not considered.
Okay, well, I mean, I'm just flabbergasted and startled that this legislation is before us. I think at the very least we've got to adopt this amendment by Ms. Jackson-Lee, which says that no, you can't nullify someone's rights to sue if they have a valid, actionable cause simply because they didn't file an administrative comment. The chairman said, well, this protects the government against the possibility that a new argument would be raised. Well, if that's the rationale for it, then we should say you don't have a right to bring a suit if the argument wasn't raised before. But this takes place, this amendment would operate even if the argument were raised by 1 million people, as long as the plaintiff in the particular case hadn't raised it himself or herself. That just doesn't make any sense. So I want to speak in very strong favor of the Sheila Jackson Lee amendment, and I want to go on record as saying I think that this whole enterprise is unconstitutional. I've never seen anything like it. Essentially, we're trying to strip people's administrative law rights in one particular case in order to gerrymander the outcome of one piece of litigation. I yield back.
I thank the gentleman, and I agree with his comments. And again, it is highly problematic to try to prevent a procedure or short-circuit a procedure under the National Environmental Policy Act by amending the Administrative Procedure Act, and in any event to do it only for one project, and in many respects ex post facto, because the permitting, the comment period is already expired, and you're saying to people who may have been expecting to sue next week, no, you can't, ex post facto. I yield back.
The question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the noes have it. The amendment is not agreed to.
You have a roll call on that, Mr.
A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Labrador? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Rutherford? Ms. Handel? Ms. Handel votes no. Mr. Rothfuss? Mr. Rothfuss votes no. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Richmond votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes aye. Ms. Dimmings? Ms. Dimmings votes aye.
The gentleman from Iowa, Mr. King.
Mr. King votes no.
Gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 11 members voted aye, 15 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. 4423?
Mr. Chairman,
For purpose, the gentlewoman from Washington seek recognition.
move to strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. I'm going to oppose this bill when it comes to a vote, and I want to thank our ranking member for his excellent statements. I want to thank the gentlewoman from Texas for her amendment, which would have made a bad bill slightly better. I want to make clear that this bill does not protect public drinking water supplies and rather endangers protections provided by the National Environmental Protection Act, and it is an attack on people's right to have their day in court. But, Mr. Chairman, I would like to use my time to say that I am stunned that we are not having any hearings in Judiciary Committee on the travesty that is happening across the country as asylum seekers are being denied their legal rights to have a credible fear hearing along the border when they come to the border. I, this last weekend, went to the federal prison where 206 individuals were transferred from the Texas border primarily the Texas border, to a federal prison because all of our ICE facilities are full because of the mass detentions and deportations of people across this country that this administration and some of my colleagues on the other side of the aisle are allowing to happen. These individuals that I met with, 206 people who were transferred to a federal prison, I met with all the women who were part of that group, 174 women who were part of the group held in 3 separate pods. They were women who came from 16 countries, from Cuba, from El Salvador, from Guatemala, as far away as Eritrea. And Mr. Chairman, it was horrific what I heard. In spite of the fact that this was a federal prison, at least I will say it's a government-owned and operated facility with some accountability and some standards. These women said this was the first place they were treated like human beings. The majority of them had children, a large majority of them had children who had been forcibly removed from them at the border when they should have had a credible fear hearing for asylum, but instead they were prosecuted in mass courts with 75 to 100 people being prosecuted at one time. They were taken away from their children. Not a single one had had the opportunity to say goodbye to their children, to explain to them what was happening. In some cases, they were deceived, told they were going to be taken to take a photograph, came back and found that their children were no longer there and were in rooms right next door to their children where they could hear their children screaming for them. Mr. Chairman, the children were as young as 1 year old. 1 year old. And then these mothers were put into facilities that they call the icebox and dog pound. You know why they call them the icebox, Mr. Chairman? Because the temperatures are so frigid that it is freezing cold. They cross the Rio Grande, they turn themselves in wet, and they're put into an icebox and denied access to clean water for 5 days in some cases. A sink with dirty, chlorinated, filthy water. And on top of that, they were called filthy, disgusting. They were told that families don't exist in this country when they asked to be reunited with their children. They were told that they would never see their children again. And in fact, over 50% of these individuals had been held for longer than 2 weeks. Many of them, about 35 to 40%, had been held for more than a month, had not even seen their children, did not even know where their children were. What parent in this United States of America could say that this is the way we should treat people? I am outraged, Mr. Chairman, absolutely outraged at what we are doing. And I want to read to you, because this all comes from the Trump administration's zero-tolerance policy, some of the stories of the women we're talking about. One woman from El Salvador has 3 children, had 3 children. The first child was murdered by gangs. The second child was shot and paralyzed by gangs. The third child was the only child that was safe, and she tried to do what every mother would do and bring that child to safety. She has not seen her child for over a month. She doesn't know where that child is. She has not been given a credible fear hearing. Mr. Chairman, this last policy from the Attorney General that is taking away a lifeline for survivors of domestic and gang violence is outrageous. Here's the story of the woman that the Attorney General just weighed in on her case. For over 10 years, Aminta Cifuentes' husband beat, raped, and tormented her. He poured turpentine on her and tried to set her on fire, resulting in permanent hearing loss. He once hit her in the stomach so hard that she gave birth prematurely and punched her with such force that she still has difficulty breathing and speaking. She tried to get protection from Guatemalan law enforcement multiple times, but the police dismissed her complaints as marital problems and told her to go back home. When she tried to leave her husband, he hunted her down. She finally fled to the United States, where even there her husband's threats followed her. This is the case that the Attorney General has said the United States of America has no grounds to hear this case. What are we coming to And why are my good colleagues on the other side? I know there are mothers and fathers on the other side who must be tormented by this. If you plan to not say anything, you have to go home to your children at night and tell them why you would allow this to happen to children in the United States of America. We should be having a hearing on this, and Mr. Chairman, I request respectfully.
The time of the gentlewoman has expired.
I request respectfully that we have a hearing in this committee where we bring the Attorney General before us to tell us what we are doing with these camps on the southern border and in these prisons with women who are seeking asylum and who we are violating
time of the
in
gentlewoman
the
has
international
expired.
human rights law.
A reporting quorum being present, the question is on the motion to report the bill.
Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
Mr. Chairman.
Chairman.
Mr. Chairman, I seek recognition.
What purpose the gentleman from Wisconsin seek recognition?
Mr. Chairman, I move the previous question on the bill and all amendments thereto.
Questions on the motion for previous question. All those in favor respond by saying
Chairman,
aye.
I object to the motion.
Those opposed?
Point of order, Mr. Chairman.
The chair, the ayes have it, and the previous question is ordered. Recorded votes requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes yes. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Ms. Handel? Ms. Handel votes yes. Mr. Rothfuss? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no. Ms. Demings? Ms. Demings votes no.
The gentleman from Florida, Mr. Gates. Gentleman from Florida, Mr. DeSantis.
Mr. DeSantis votes
Gentleman
yes.
from Texas, Mr. Poe.
Mr. Poe votes yes.
Gentleman from Louisiana, Mr. Johnson.
Mr. Johnson votes
Gentleman
yes.
from Pennsylvania, Mr. Rothfuss.
Mr. Rothfuss votes yes.
Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 16 members voted aye, 12 members voted no.
And the previous question is ordered. The question occurs on the amendment in the nature of a substitute. All those in favor respond by saying aye. Those opposed, no. The chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. A reporting quorum is being present.
Mr. Chairman, point of order.
There's no point of order in the middle of a vote.
We're not in the middle of anything. Point of order, Mr. Chairman.
A reporting quorum being present, the question is on the motion to report the bill H.R. 4423 as amended favorably to the House. Those in favor respond by saying aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably.
Roll call vote, please.
Recorded vote has been requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. Isa votes aye. Mr. King? Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Collins? Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Ms. Handel? Ms. Handel votes yes. Mr. Rothfuss? Mr. Rothfuss votes yes. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no. Ms. Demmings? Ms. Demmings votes no.
The gentleman from Texas, Mr. Poe.
Mr. Poe votes yes.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 16 members voted aye, 11 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 5954 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5954 to amend Title 18 United States Code to clarify the meaning of the terms act of war and blocked asset and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. Congress enacted the Anti-Terrorism Act of 1992 in order to help combat international terrorism and to provide some level of financial justice to American victims of terrorism. The 1992 Act added a civil remedy to the ATA's existing criminal regime, removing jurisdictional hurdles that often confounded terrorism victims' ability to get their day in court. And the Act has been largely successful. However, from time to time, the 1992 Act has also needed modifications to ensure that it is fully serving its purposes. For instance, just last Congress, in the Justice Against Sponsors of Terrorism Act, I helped lead the charge in the House to amend the civil liability provision to make sure that those who aid and abet or conspire with foreign terrorist organizations are liable under the ATA. In addition, in 2012, the Judiciary Committee worked to lengthen the statute of limitations on civil ATA claims to provide victims with the time they need to file these often complex lawsuits. The bill we are considering today, the Anti-Terrorism Clarification Act, builds on these previous technical amendments to the ATA. It makes 3 needed improvements in order to better ensure that victims of international terrorism can obtain justice in U.S. courts against terrorists and their supporters. First, the bill clarifies the ATA's act of war exception. Defendants accused of aiding and abetting acts of international terrorism have been attempting to use this exception as a means of avoiding civil liability, even in cases in which the plaintiff's injuries were caused by the actions of designated terrorist groups. For example, in Kaplan versus Central Bank of Iran, the defendant financial institutions successfully argued that rocket attacks against civilians carried out by Hezbollah, a designated foreign terrorist organization, were acts of war and thus outside the scope of the ATA's civil liability provisions. The act of war exception should not be a liability shield for those who aid or abet attacks carried out by designated terrorist organizations. This legislation amends the definition of act of war in the ATA to clarify that the exception does not apply to U.S. government-designated foreign terrorist organizations or specially designated global terrorists. Second, at the urging of Representative Posey, the author of the Captive Act, we included language in the bill to strengthen the ATA's civil enforcement regime by permitting victims of narco-terrorism to satisfy their court-awarded judgments with the assets of foreign narcotics drug kingpins. Assets blocked by the federal government under the Kingpin Designation Act are not currently available to victims, leaving victims of the FARC and other narco-terrorists without a meaningful method of getting compensation for their injuries. Finally, this legislation addresses recent federal court decisions that have called into question the continued ability of victims to bring terrorists and their supporters to justice under the ATA's civil liability regime. The ATA was specifically designed to provide extraterritorial jurisdiction over terrorists who attack U.S. nationals overseas. However, these recent cases have severely limited the extraterritorial scope of the ATA. The Anti-terrorism Clarification Act amends the jurisdiction and venue section of the ATA to make clear that defendants who take advantage of certain benefits provided by the U.S. government shall be deemed to have consented to personal jurisdiction in the U.S. courts in ATA civil actions. No defendant should be able to accept U.S. foreign assistance while simultaneously dodging responsibility in U.S. courts for aiding or carrying out terrorist attacks that harm Americans. I want to thank Ranking Member Nadler, along with Senate Judiciary Chairman Grassley and Senate Commerce Committee Ranking Member Nelson, for joining me in introducing this bicameral and bipartisan bill. I urge my colleagues to support us in passing this legislation to clarify ambiguities in the ATA that terrorist sponsors have exploited to evade liability, so that we can help ensure that Americans are able to hold terrorists and their supporters accountable. It's now my pleasure to recognize the ranking member of the committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. I'm proud to be the lead Democratic co-sponsor of H.R. 5954, the Anti-terrorism Clarification Act of 2018. I support the bill. I support the comments made by the chairman. I support the nature in the amendment nature of a substitute that's going to be offered. And I want to offer my eloquent and lengthy statement in support of the bill into the record.
Without objection, it will be made part of the record.
Thank you. But I want to take a moment now to object to what I believe to be the majority's abuse of power that we have just seen in this committee to silence debate on an issue that is squarely within our jurisdiction and is of pressing importance. The shutting down of debate to silence members by use of the previous question is inconsistent with this committee's history as a place of full and collegial debate of some of our nation's most important issues. I want to associate myself with the remarks of Ms. Jayapal. I want to further say that we're overcome with examples of the conduct of an administration that appears to lack a moral compass and stands in defiance to our nation's history as a beacon of freedom and a refuge for the oppressed, and that shames our country by the actions it is taking. From the ripping of thousands of children from the arms of their parents as a deliberate means, and the administration has said so, we're going to rip children away from their parents in order to deter people who are fleeing violence from seeking political asylum. Forget the motive. We're going to rip thousands of children from the arms of their parents. That's inhuman. It's inhuman, and it is degrading to our country. We can debate immigration policy, but it's hard to debate deliberate infliction of cruelty and torture on victims of violence, of people who are seeking asylum. I always thought that when someone comes with a claim of asylum, You first say, okay, is there a credible fear? You have a credible fear hearing. You have an adjudication as to whether the asylum claim is justified. You don't first arrest the person and take the kids away, hoping to deter other people from fleeing to this country. That's inhuman. It is beyond, almost beyond description. I want to say disgusting, but I hate to use the word disgusting about the action of United States officials, but it's the only way we can characterize it. And for the Attorney General suddenly to decide that victims fleeing violence, domestic violence or other violence, cannot get political asylum as a class, not as that violence, that the infliction of murder and mayhem should not be subject to consideration for asylum, is also beyond the traditions of this country. This is the committee with jurisdiction, and we ought to be holding hearings to see what are we doing? What is the administration doing? Do we approve of what they're doing? Should we say, okay, go ahead? Should we say, no, stop? That's the job of this committee. And instead, we're sitting here debating worthy bills and some not so worthy bills, but nothing of such crucial and human immediacy. And it is shameful that we not debate this. It's shameful that we not act on this, that we not consider this when we're faced with an administration doing these terrible things in our name. And it is shameful that we use the previous question to shut down debate on this committee, to shut down so that people can't raise it, as if perhaps the people who moved the previous question are afraid of the debate, are afraid of what may come out, are afraid that they have no responses, or that they have no responses that will stand the light of day. So I certainly hope that we will have a hearing very shortly, that we will call the DHS secretary to testify, and that we can look into this question. That is our job. Whether we end up approving, I will never approve of this policy, but that's not the point. Whether we as a committee end up approving this policy or modifying it or suggesting changing it or approving it, it's our job to look into it. It's our job to hold any administration accountable, and I certainly hope we'll have such a hearing very quickly. I yield back.
The gentleman yield.
Sure.
I just want to point out to the gentleman that we are working diligently. We had scheduled and then we had to reschedule, but we are going to schedule an oversight hearing of the department, and the secretary will appear, and questions of the nature the gentleman has raised will be available to be asked soon.
I appreciate that. I might suggest that we ought to have a hearing not overall on the DHS, but specifically on these policies, which are very new policies, which are very stridently different from any we've pursued in the past, without congressional consideration, certainly, and they're deserving of their own hearing by themselves. I yield back.
I now recognize myself for purposes of offering an amendment. The clerk will report the amendment.
Amendment to H.R. 5954 offered by Mr. Goodlatte. Page 3, strike line
Without objection,
24.
the amendment will be considered as read, and I'll recognize myself to explain the amendment. My amendment fine-tunes Section 4 of the bill in order to ensure that the provision applies in a fair and balanced way to both victims and defendants in ATA civil cases. Section 4 is the section of the bill that provides for consent to personal jurisdiction for defendants who accept certain foreign assistance from the United States or benefit from a waiver or suspension of the anti-terror laws so that they can locate an office or headquarters in the United States. First, this amendment enhances the fairness of the application of this provision to defendants by making clear that the section does not begin to apply until 120 days after date of enactment. This will ensure that defendants have knowledge that their acceptance of certain benefits extended by the United States will constitute consent to personal jurisdiction in civil ATA cases. Second, the amendment provides that consent to suit does not have to continue in perpetuity. Rather, Section 4, as amended, will now cease to apply to any defendant who stops receiving U.S. assistance for a period of 5 years. As with the previously described change, this will enhance meaningfulness of a defendant's consent to personal jurisdiction. Third, the amendment balances the interests of the victims of terrorism by changing the applicability of the section so that it applies to existing ATA cases. The bill, as introduced, only applies to cases filed after the date of enactment. This is a fair balance to strike because the amendment is pushing back the application of Section 4 until 120 days after the date of enactment. I hope my colleagues will join me in supporting this amendment, which I think makes Section 4 of the bill strike a better balance of interest between potential defendants in these lawsuits and victims of terrorism.
Chairman,
For the purpose of the gentlewoman from Texas, seek recognition.
I rise to strike the last word.
Gentlewoman
Ask
is
unanimous
recognized for
consent.
5 minutes.
Mr. Chairman, I rise to support the amendment for the additional due process provisions that it gives. I believe under the circumstances, when we hear the word terrorism, of which this bill deals with, we should also be mindful of the principles of the United States, which do include principles of due process. Mr. Chairman, might I also make the point that I associate myself and desire to associate myself with first the words of Congresswoman Jayapal, and as well to associate myself with Mr. Nadler. As you well know, we have served together on this committee for the period of time that we are well aware that this committee has jurisdiction over the internal actions of ICE. You're also aware that we proposed the policy under the Immigration Committee of dealing specifically with unaccompanied children, meaning those who specifically came to the United States unaccompanied. In addition, many of us during that crisis, myself, Ms. Loughran, went to the border, and I personally witnessed and handled or took into my arms unaccompanied children that were fleeing the persecutions of massive gang violence, that it was so fearful that parents in the tradition of Moses were sending their children to a safe refuge. To take and abuse that policy, as this administration has done, with no premise in law, no jurisdictional basis to deunify, to separate, to rip, to demean, to jeopardize the lives of children, to ruin them for life, to alter their psychic, to maybe never find the children again. My God, if we have all these children in places taken from parents without their permission, and in family law in states, the highest priority is that parent. You have to go to court to separate that parent's rights from that child. And here we are ripping them away. Let me just say, this past weekend, I was with the Guatemalan community. That volcano is worse than we might have thought. 1 million people are displaced. Guatemala is not a large country. We expect massive numbers of people that will possibly flee because of a natural disaster. And then I think my colleagues should know, and I think the Congresswoman made it clear, she alluded to it, and this is where we should have the hearing, is that there is a massive, the process of any form of due process is completely alleviated. The persons seeking any relief are hauled into court 50, 60, 75 at a time. The Southern District, of which this area is in, is so short of immigration judges. We have a 50,000 case backlog. And I am led to believe that there is no relief down at the border. There is no increase in immigration judges at the border. And so you are hauling in massive numbers of people who do not speak English, who are, by their asking for asylum, as the ranking member said, have a right to the establishment of credible fear. The other point is that Hondurans who are coming are speaking in their indigenous language. Many of them are speaking in their indigenous language. There are no translators for the indigenous language. So they don't even know what is going on, and they certainly don't know where their children are. So, Mr. Chairman, that hearing, I would associate myself for a hearing, but an overview hearing is not the emergency that we have now. And really, this committee should be the committee, regardless of what side of the aisle you are on immigration, to loudly tell, as I have asked, for the Secretary of Homeland Security and this administration to cease and desist immediately from ripping children away from parents. There are legitimate facilities, not the best, as has been evidenced, that children and family can stay together. And if they lose these children, this will be an international humanitarian crisis of which the United States will be a long time overcoming, because the world is watching and they are appalled. They can't even imagine that people are ripping away, as bad as the migration system is in Europe, meaning those who are fleeing and the tragedy of drowning, they are not, as they land, if they land on the shore, are not separating families. So this is a violent act, and I know that none of us, no matter what side of the aisle, parents and grandparents who sit on this particular panel, or those who love children on this panel, cannot imagine, Mr. Chairman, this continuing to go on. And I don't know why the Trump administration is turning a blind eye when just a month ago in April, 2 months ago, in Child Abuse Month, he got up to speak about the value of the child and the parent. This is gross and violent child abuse. Mr. Chairman, I would ask that our hearing be on this question, separately on this question. And with that, I yield back.
Has expired.
Mr. Chairman,
Purpose of the gentleman from Georgia seek recognition.
I move to strike the last word.
Recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in support of the amendment and also in support of my dear colleague, Congresswoman Jayapal, who, with eloquence and controlled emotion, spoke on an issue of prime concern to many of us in this room today. Unfortunately, not enough of us, not the majority of us. Some of us care about children. Some of us care about people. Some of us agree with Donald Trump when he describes certain folks as animals. And certain ones of us have adopted that view, obviously and clearly. Some of us believe that people coming across our southern border are animals. And so Representative Jayapal expressed her view on this, and as a result, ran everybody out of the room on the other side of the aisle. I guess the truth hurts, Mr. Speaker, Mr. Chairman. The truth hurts. And when the truth is being told, it's unavoidable to us here on this side of the aisle. So we understand that even in cases of divorce where children are deprived of one of their parents, it has a profound impact on the child. Studies show that. That's why so many parents wait until their children are able to accept the trauma of separation and divorce before they actually take that step. Some parents really care about their children. And the majority of those people coming up through our southern borders, they are just like us. They care about their children too. And their children are just like children here in America. They hurt when they're separated from their parents. When children are separated from their parents, they struggle emotionally for the rest of their lives. They suffer an extreme sense of loss when they are pried from the arms of their parents at the border and taken away by strangers and housed like animals, like we treat cattle. We put the parents through one chute and put the children through another chute, treating them like animals. We separate the children, put them in a place where nobody loves them, where they basically have no parental guidance whatsoever. They are housed in prisons, in detention, in cages, like animals. And those children hurt just like American children. They suffer the sadness of not being with their parent. They suffer the isolation and loneliness that comes with separation. It will result in societal difficulties as they age, because they will be the ones with the behavioral problems. They'll be the ones with who will use drugs and alcohol to try to numb the pain that they have never been able to deal with. They will become pregnant. They will be the ones that are committing the delinquencies as juveniles, and as adults, they'll become hardened criminals. What are we doing to ourselves? Because we know that we live in a global economy. When this administration leaves office, we will not be able to keep our borders closed. People, as they do overseas, take actions that impact Americans here in this country. You will not be able to escape the results of what we're doing to these children. We are taking innocent children and turning them into monsters that will one day come back to haunt us. We should not be doing this to these children. And I'm glad that you brought it up, Congresswoman Jayapal. It's a tough subject. Nobody wants to hear it on the other side of the aisle, but we care about people, we care about children, and it's wrong what is going on in America. And with that, I yield back.
Mr. Chairman,
First, the gentleman from Rhode Island seek
I
recognition.
move to strike the last word.
Recognized for 5 minutes.
Thank you, Mr. Chairman. I support the amendment. I too want to spend a moment to address the really important issue raised by the gentlelady from Washington, and associate myself with her remarks and the remarks that strongly criticize the shutting down of debate by the committee chairman on this important issue. I know these are hard stories to hear, and I know nobody wants to hear them because they're devastating to listen to. But imagine how devastating they are to experience them. To be a mother sitting in a room and hear her child crying, and there's nothing you can do to soothe those cries. This is not who we are. This is unspeakable violence against children. In fact, it's so bad that the United Nations condemned the United States, that this practice of ripping children from their parents violates international law and basic human rights. It also violates our own law. You know, we hear from this committee, this is the Judiciary Committee. We have laws that we've enacted about asylum, when you're eligible for it, how that determination is made. None of that is happening. And instead, we hear stories of detention, arrest, separation, the most horrific examples of violence against children in the history of our country, maybe. And our committee has a responsibility to do something about it, to bring the Attorney General, bring the Department of Homeland Security Director here to answer questions about this practice. These are violations of laws duly enacted by Congress. Asylum seekers have rights. They are fleeing the most horrific violence, rape, threats of murder, child trafficking, unspeakable violence. They come to America because they know if they come here and they can make a claim for asylum, that they're really in fear, that something really awful is happening in their lives, that they have a process, a lawful process they can go through. But what happens? They get here and they get arrested and put in a cage, and then they're separated from their children. And agents tell them, make sure everyone knows this is what happens so people will stop coming. Those agents don't get to make the laws in this country. That's our responsibility. And the examples that Ms. Jayapal heard about should alarm and disturb every single one of us. And we haven't had a single hearing to examine this policy, which is a significant departure from all that is decent and right and the tradition of this country. We haven't had a single oversight hearing to examine this, to hear the cries of these children and these families. But we did have a hearing today on the North Texas water supply, some project in Texas. I'm sure to the people in that area it's important, but it seems to me the American people are demanding answers about what the impact is of this zero-tolerance proposal. We have a long tradition in this country of understanding our responsibilities to be a refuge of people that are fleeing violence and seeking a new way of life. And we set up a whole structure, a whole set of laws to govern how we can do that in an orderly way. The American people expect us to comply with those laws we've enacted. And what we are hearing and seeing and reporting in the media is evidence of a gross violation of basic human rights, a violation of well-established law and tradition in this country. And we can't seem to get our Republican colleagues to do anything about it. We have to fight to get our voices heard in this committee, to squeeze in between the gavel, because they don't want to hear about this. Well, guess what? The American people expect something to be done. This is intolerable, it's disgraceful, we should all be ashamed it's happening, and we have a responsibility to fix it. And this committee has jurisdiction, and I'm asking you, Mr. Chairman, to bring before the committee those responsible for developing this policy, executing this policy, and people who have been victims of this policy, so we can understand the gravity of this and fashion a solution to it. But no longer should we expect that the Democrats on this committee are just going to sit there and talk about the North Texas water supply or some other bill to fill the time when real problems persist in this country, and we are undermining and undoing the basic rule of law, our long-standing tradition of being a beacon and a light to the world as a place you come for the protection against violence and discrimination and harm, and most importantly, a country that values families and values the importance of keeping families together. America can never be known as a country that facilitates the ripping apart of families, sending children into detention away from their parents. That is not who we are. And so I ask you, Mr. Chairman, to adjourn this hearing and convene a hearing immediately with the Attorney General, the Secretary of the Department of Homeland Security, ICE officials, so that we can have a real discussion and the American people can see what this policy is doing and the individuals responsible can be held accountable. With that, I yield back.
The chair thanks the gentleman. We have an important piece of legislation, bipartisan legislation before the committee.
Mr. Chairman.
The question occurs on the amendment offered by the chair. All those in favor of the amendment respond by saying aye. Those opposed, no. The ayes have it, and the amendment is agreed.
Point of order, Mr. Chairman.
What purpose does the gentleman from Maryland seek recognition?
Move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you very much. I favor the amendment, and I want to add
The amendment is passed.
Well, I tried to speak beforehand, but okay, I favored the amendment. I want to add my voice to the chorus of opposition to this outrageous and
That's not relevant to the business before the committee today.
But was I not recognized for 5 minutes,
The gentleman was recognized.
Okay, well, I'm going to use my time
then.
then. I plan
That's
to...
the case.
Excuse me?
And if it continues, we'll have to use the same procedure we used in the last matter. I don't think this is a wise thing to do when we have important business before the committee.
Mr. Chairman, has it not always been the practice of this committee that people can be recognized and they can speak to the matters that they think are important to the Judiciary Committee and to the people of the United States and their constituents?
Actually, it is not. And that is why, on occasion, the previous question has been used when the minority party filibusters an issue. So the gentleman can proceed. He's recognized for 5 minutes.
Look, I understand the impulse not to talk about what's taking place in the name of the American people, but Ms. Jayapal has properly brought to the attention of this committee something which is of urgent importance to justice in the United States of America. What we have going on under the guise of this zero-tolerance policy is the forcible separation of children from their parents. And many of the people who are being separated from their children are here with valid asylum claims. As Mr. Cicilline says, this is not who we are. This is not what the United States of America is. Thomas Paine said America was founded as a haven of refuge for people fleeing from religious and political oppression and violence from all over the world. That's why we've got the Statue of Liberty, which says, "Give me your tired, your poor, your huddled masses yearning to breathe free." That's who we are. As America, we are all the descendants of immigrants, except for the descendants of slaves and the descendants of the Native Americans. Now, we've got people arriving in America fleeing domestic violence, gang violence, government oppression. Many of them are coming in lawful ports of entry and are still being separated from their children. Ms. Jayapal tells us because we haven't had a hearing on this, so what we're getting is direct firsthand testimony from members of Congress who are trying to go to the scene of this crime against human rights. And she tells us that there are mothers who cannot stop crying, and they can hear their children crying in neighboring rooms as they're being taken to God knows where. Mr. Chairman, if we can have a hearing on this singular exception to the environmental laws of the United States for a North Texas water district that doesn't want to give people the right to sue, to vindicate their environmental rights under NEPA, certainly we can have a hearing about what is taking place in the name of the American people at the border and now all over the country as these children are relocated. And we read that the White House is looking to erect tent cities to house unaccompanied children. More than 1,000 children are going to be put in makeshift tents as they're separated from their parents and their families. This rang a bell with me from 1984. It was a totally Orwellian policy, and sure enough, you go back and check out Orwell. O'Brien says, "We have cut the links between child and parent. Children will be taken away from their mothers." This is an Orwellian policy. It's a policy that is reflective of an authoritarian cast of mind, not the cast of mind of the greatest liberal democracy that ever existed. Who are we becoming? I want to ask, if she would yield for a question, Ms. Jayapal, a question. Is it really the case that people are arriving with asylum claims and causes of action in lawful ports of entry?
Would the gentleman yield?
By all means.
So I would just ask the gentleman, wasn't it under a Democratic Congress and a Democratic administration that this policy that does not allow children to be held with their parents in detention was passed into law? That is the crux of this problem, and that's what needs to be addressed. And in fact, we're going to have two bills on the floor next week that will address it. As I said before, we're going to have the Secretary of Homeland Security here soon. You'll be able to ask her these questions.
Okay.
But it needs to be addressed legislatively, and that is the crux of the matter. So you're welcome to debate it here, but there is a better time and place to do that than when the committee has other important business, including protecting people who are the victims of terrorism by passing legislation to enable them to have
reclaiming my time.
Thank you
Thank you very much, Mr. Chairman, and I would love to hear a full elaboration of that position at a hearing that you call this week for our hearing to examine this policy that's taking place in the name of the American people. Proceeding with my question for Ms. Jayapal, is it true that people are arriving at lawful ports of entry and still being separated from their children?
That is correct. These are individuals who are coming to the United States seeking asylum. The process should be that they get a credible fear hearing. Not a single one of them that I met with, 174 women who were held in a federal prison because we don't have enough space in detention centers because we've mass deported and detained immigrants across this country. These are all individuals seeking asylum. They have not been given that credible fear hearing. And I just want to point out that the UN Human Rights Office has said that the practice of separating children from families violates their rights and international law. And the UN High Commissioner for Human Rights said it amounts to arbitrary and unlawful interference in family life and is a serious violation of the rights of the child. And this all, let us be clear, comes from the Trump administration, Jeff Sessions' zero tolerance policy at the border that has facilitated and encouraged border agents to be absolutely outrageously cruel to people and to hold them in conditions that no matter what your policies are, nobody should be held in those conditions.
Time of the gentleman has expired. The reporting quorum being present, the question is on the motion to report the bill H.R. 5954 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all the members for attending. The markup is adjourned.